Okay, welcome everyone. I am Doug Kysar, and I'm delighted to welcome you to the first speaker event of the spring semester for Yale's Law, Ethics, and Animals program. Today, we are thrilled to be joined by Maneesha Deckha of the University of Victoria. In subsequent events this semester, we will engage with Dale Jamieson of New York University, Jessica Eisen of the University of Alberta, Angela Fernandez of the University of Toronto, and the authors of a major new book in animal philosophy, Laurie Gruen of Wesleyan University and Alice Crary of the New School and Oxford University. In addition to being some of the most exciting thinkers in the areas of animal legal theory, animal philosophy, and animal studies, these speakers also share the distinction of being members of BASAN, the Brooks Animal Studies Academic Network. We are enormously grateful to the Brooks Institute for Animal Rights Law and Policy for founding and supporting the BASAN community and for including Yale's LEAP program within it. It's been an extraordinary privilege to be able to engage and collaborate with these and other members of BASAN. Our speaker today offers a perfect example of the kind of brilliant, innovative, and ambitious academic work being produced by BASAN members. Maneesha Deckha is professor and Lansdowne Chair at the Faculty of Law at the University of Victoria, where she also directs the Animals and Society Research Initiative. Her research interests include animal legal studies and critical animal studies, feminist animal care theory, and feminist analysis of law, socio-legal studies, and reproductive and end-of-life ethics. She's published widely in law journals in Canada, the US, and the UK, as well as in numerous edited collections and leading academic journals in other disciplines. Maneesha's recent book, Animals as Legal Beings, Contesting Anthropocentric Legal Orders, has been heralded by one reviewer as a must-read for anyone who cares about more than humans, a book that, in the words of another reviewer, must be confronted by anyone seriously concerned with the legal status of animals. I'll add my own superlative by saying I think it's the most important book in animal legal theory published in at least 30 years. So we're really thrilled that Maneesha has agreed to speak with us today and that she's going to share this incredible resource with our audience. I encourage you to acquire your own copy if you haven't already as soon as you can. So without further ado, Maneesha, please, the floor is yours.
Thank you so much, Doug, and to Yale and the LEAP program and the Brooks Institute for this very generous introduction and wonderful opportunity to speak with all of you today about the recent publication of this book. I'd like to start off by acknowledging, with respect, the Lekwungen peoples on whose traditional territory my university, the University of Victoria, resides, and the Sanghees, Esquimalt, and Saanich peoples whose historical relationship with the land continues today and remains profound. I think that a territorial acknowledgement such as this is an opportunity to recall the multi-species effects of colonialism, both historically on individual animal lives and lives of other non-humans, as well as in whole species, as well as think about, of course, the ongoing effects today. This book is very much, an intervention, trying to make an intervention in that kind of space, in this situation, through the legal system, which, as we may know, is a primary agent, has been, still is, of colonial legal relations and social relations. A hallmark that I suggest is the ongoing treatment of animals as property. So the book is titled Animals as Legal Beings, trying to propose and afford a new legal subjectivity. And the subtitle is Contesting Anthropocentric Legal Orders. So let me just outline what I'd like to go over. It's basically the argument of the book. And so first, just briefly talk about some of the purposes and departure points in the introduction, and then talk about really the gist of part one, which is an argument against property for animals, but also personhood. And then part two set out what I propose instead as a legal subjectivity, which is beingness, or animals as legal beings, and then spend some time on kind of the discussion, the conclusion, which is to outline, some practical first steps toward change to try to implement this proposed system, should there be political will to, of course, go forward with that. Okay, so the purposes are quite a few, but I just want to highlight two main ones here on the left side. So first, my intent with the book was to theorize a new transformative legal subjectivity for animals. And secondly, to kind of, take existing animal law scholarship, or what's normally seen as animal law scholarship, as well as ethics scholarship in kind of the Anglo American tradition, which is quite situated in liberal thought, and to meld it more with critical theory, also very much popularized by Anglo-American scholars, but of course who impugn fundamental tenets of liberalism. So the theoretical background of the book kind of reflects my own theoretical formation as an academic, really very much drawing from feminist theory, postcolonial theory, and really kind of the conjunction of that with ecofeminist theory, or also known as feminist animal care tradition, and of course, perhaps newer iterations of critical animal studies. And on the right side of the column, some departure points. I go through quite a few in the introduction, but again, let me just highlight central ones. First, I want to, of course, acknowledge that law is an anthropocentric kind of phenomena. It is, human-made, and we can understand it. It's still very colonizing toward non-humans, toward animals. And I'm mindful of the critiques about the limits of law, and of course, the quick resource or resort we have to law as a resource for a change, which may not be merited at all. Taking all that under consideration, I still think the legal system is worth engaging, just given its effects, and it's symbolic and material. And so that's why I've spent some time engaging, obviously, as a career choice, and also with this book. Second departure point is that the purpose here is to take aim at human exceptionalism in the common law, which is one of the foundational colonial legal orders in Canada, the other one being civil law. That's not to say, of course, that the critique has nothing to do with other systems of law. The subtitle, if you recall, is Contesting Anthropocentric Legal Orders, so that can, of course, be transposed elsewhere. It's also not to say that the critique is not related to Indigenous legal orders as they're understood in what is known as Canada, or more broadly, but that isn't the focus of the work. So I'll just concentrate on kind of, the concern about the dominant legal system of the common law and how it regards animals as property. And third, I just want to acknowledge again that I'm using the term animals. Of course, we know the rich literature worried about what terms we use and how language, proposes certain conclusions more than others. I'm not impugning any of that, but I use it as a shorthand in the book versus any other type of terminology. Okay, well, so I want to just suggest that is a form also of epistemic violence, to lump all animals together, but I do end up using it as a convenience. Okay, so part one, what is going on in the book in part one? It's titled Beyond Property and Personhood, contesting legal objectification coming from the property status, but also humanization, which I suggest is coming from, or would come from, a personhood status. Chapter one part one has 3 parts, so 3 chapters. Chapter 1 is called No Escape, Anti-Cruelty Laws, Property Foundations. So here, very much inspired by Gary Francione's groundbreaking work in the 90s in the United States context, looking at the criminal law jurisdictions across all states. I do kind of a similar analysis in the Canadian context at the federal level. Our criminal law is at the federal level, to kind of suggest that, anti-cruelty laws are very weak and tepid, and their animals' ongoing property status is, a primary cause for that. So this is really the chapter where I suggest property is not a useful concept for animals, something which I think perhaps many of us here are familiar with that argument. So let me concentrate on chapter 2, which is perhaps the more like unusual theoretical position to hold in the animal law world for those advocating for legal reform for animals. Chapter 2 is called What's Wrong with Personhood? So here's really where I critique personhood. So I will go into that in a moment. I just want to flag for you that there's also chapter 3. And chapter 3 is really a space where I recognize that, just changing the legal status or subjectivity for animals is not going to be a kind of transformative without addressing further underlying tenets of the legal system in terms of how we kind of imagine beings. And so chapter 3 really also draws on a lot of feminist philosophy, ecofeminist philosophy, feminist care tradition, also feminist post-structuralism to kind of reimagine just the hyper-rationalism of the law and bring the kind of body and embodiment back into the law. But as I've said, let me just focus here on the argument about what's wrong with personhood. Because I mean, this is probably the most controversial part of the book. So drawing from critical theory, so a lot of feminist theory, anti-colonial theory, critical race theory, disabilities theory, that really, have scholars addressing the problems of a focus on reason and the rational across kind of intrahuman hierarchies. I build on that work as well as work of post-human scholars and ecofeminist scholars and critical animal studies scholars, just to say that even though personhood in common law jurisdictions has had kind of an open textured life, right? There's not one definitive concept of personhood, and we can understand different topologies, as personhood scholars have pointed out. There is a strong pull of what is known as the paradigmatic person or the rationalist concept of personhood. So we know that corporations are persons and have been for centuries now, quite uncontroversially in terms of acquiring that status. So yes, the empty vessel idea of personhood is available. Yet, as Anna Greer has pointed out in her work, that even kind of the corporate rights empty vessel understanding of personhood really also kind of turns to the rationalist vision of personhood that is so prominent as well across multiple jurisdictions, common law jurisdictions, to understand what is a legal person. And so the paradigmatic person is theorized as someone who is, just always of the mind, always, a rational, self-interested, self-maximizer that really has no body and is seen to be immediately independent and not in relations with anyone, right? So that person who is contracting, who is asserting their property rights and moving forward in the world. Okay, so the first sort of problem with this understanding of personhood, or what Anna Greer and others have called laws anthropos, is that, actually this rational agent is presented as neutral, but if we unpack it, we can understand that it's very much a marked type of body. It is, has a certain dominant race, dominant gender, dominant class, dominant idea of ability, and of course, a dominant species identity. And this vision of personhood is very much, in focusing on the capacity for reason, is marginalizing other non-normative types of ways of being in the world and other non-normative bodies. And actually, there's a disavowal of the body, even though we know that all human beings, even paradigmatic persons who might actually exist, have a body. Okay, a second set of problems that I discuss in chapter 2 are here titled The Problems with the Conferral of Personhood. So here I draw from critical theory talking about kind of the colonial use of personhood and the civilizational narratives it has been important for that obviously have stratified sets of peoples, nations, but also looking at very, I don't want to suggest that it's just a historical problem that could be corrected by the right kind of definition applied to personhood. That it's, I really want to suggest that there's an imprint into personhood which is not easy to fix. And here I've drawn upon scholars who've suggested that the person property divide in the common law is actually very closely mapped on to the human animal divide. So that it just doesn't make sense to try to put animals into the person category because it's so completely occupied by this idea of the human, even as we know that the legal system has admitted other non-humans, really corporations or ships, into the category of person. And so a third then related problem is that when we try to extend personhood to previously excluded subjects, and of course this has happened in the human realm, and we know that there's litigation and other efforts going on in the non-human realm, we find that it's an assimilationist type of narrative that is kind of produced or goes forward despite our best intentions, because we are kind of pressured to argue for the excluded subject, who we may now want to be seen as a person in the eyes of the law through the human benchmarks that are there for the paradigmatic person, or what are seen as human benchmarks, i.e. the rational actor. So this then, of course, creates a situation where it's certain animals that are privileged in this space. Now, I don't want to suggest that the Non-Human Rights Project or other such organizations aren't doing important, brave, ambitious, groundbreaking work, or that it's not worth thinking about kind of the animals that are seen to be humanized in certain cultures. Certainly it is, right? And so it's not, of course, just the Non-Human Rights Project advocating for animals through personhood types of litigation. We also have kind of in, just in public discourse, the kind of suggestion to the public that animals deserve more, i.e. perhaps a personhood status and the rights that come with it, because they've been treated horribly and because they are intelligent creatures that are going to be understanding their captivity and all the effects that follow. This is an example of a local, here in Victoria, current exhibition at the Royal BC Museum on orcas, titled Orcas Our Shared Future. And here's a panel that I took a snap of talking about, legally captive orcas are property, but then asking the public to think about, even in the wild, what type of legal protection might orcas need to be treated properly, and then suggesting personhood, it is something suitable. And in Canada, we've also had traction 2 years ago, quite phenomenally, in terms of ending the captivity of whales and dolphins. Of course, the existing cetaceans at 2 of our marine water theme parks were grandfathered in. But this is the first time that Canadian legislation is saying, let's end the captivity of certain types of animals. So there are legal results for that are available and meaningful under kind of personhood type of litigation. But I don't think it's a coincidence that all these examples are showcasing the animals that the public is ready to accept as human-like because of this kind of scientific rationale that these animals are able to think at a certain capacity to reason. Certainly not all the legal discourse that led to these legal results or that are currently being tried in litigation center on the intelligence of these animals or their rational capacity. Right? We have arguments about kinship as well, and social networks and capacities to grieve, for example. But the discourse about intelligence and passing mirror tests and the cognitive abilities, this is still very prominent. And so I want to suggest it's not a coincidence that personhood leads to this type of discourse. And so what's wrong with focusing on intelligence and cognition capacity? Well, it's really hard to to kind of, you know, make the other animals, let's think of the farmed animals or the whoever are the non-humanized animals in a specific culture, because they don't resonate with kind of the public's idea of who's smart and who's intelligent, who's like us, to kind of come into the space of legal attention, right? And then when these animals do come, perhaps in a rare case, as we had, you know, with our pig save trial case in Canada a few years ago, that got a lot of legal attention worldwide. When such arguments about personhood for pigs are advanced, they're, you know, basically dismissed out of hand from the court, even if the pig save trial actually was successful in acquitting Anita Krantz, the founder of the pig save movement in Canada, more on a technicality than kind of the judicial acceptance of personhood for animals. And also, I think it's worth noting that the experts, or at least the female identified experts in this case, their testimony about why pigs should, you know, not be seen as property but as persons was dismissed as biased. Okay, so instead of personhood, and before I get to beingness, I also want to kind of suggest, you know, kind of in the chapter, I say, you know, even if I'm wrong about that critique and the possibilities of personhood, I think that we're at a moment, we're at a juncture where it's possible to think otherwise, and we're not standing to lose that much for animals, right? So we know that personhood is not something that is being embraced by the legal system for non-humans, right? Even though there might be a few little developments here and there, and perhaps building, and perhaps we are going to see some type of huge shift in the coming years. But, you know, I would ask, you know, what do we have to lose by choosing another type of subjectivity for animals and actually forwarding that, that's not so tied to the human benchmarks model of the rationalist personhood, right? If we're starting kind of with a clean slate, let's start with a slate that actually prizes other ways of seeing animals, i.e. valuing their alterity rather than, you know, how human-like or human they can be. And so I don't think it's risking too much at this stage to say, you know, we're not going to go down the personhood route, but let's suggest another way of thinking about animals. And I also want to be clear at this point that that other way, so animals as legal beings, is meant to be as protective of personhood that personhood scholars, right, those advocating for personhood, believe personhood will be, i.e., like, you know, a trump, a shield against exploitation that a property status enables. So let me now just chart out part 2 of the book. So chapter 4 is where I present beingness as a new legal subjectivity for animals. And then chapter 5 is where I, you know, really try to sit with the possibility that I'm just reinscribing the same liberal humanism that I've heretofore critiqued. You know, the concern about drawing the line a little bit differently than where it's drawn now. So I will just go over that chapter as well. Okay, but here really is kind of the main visual for the book. If on the left side, the definitive characteristics of the rationalist vision of personhood is someone who is, you know, disembodied, independently autonomous, and just rational. So another way to think about this is, you know, if we imagine, you know, who is law's person, when jurists talk about law's person or the reasonable person, it's, you know, what are the features of this person? What do they look like? What can we say about them? These 3 kind of bullet points would come up. In juxtaposition, I put beingness. Beingness is meant to kind of, you know, oppose those hallmarks of personhood. So instead of a disembodied actor, we have an embodied being. Instead of someone who's valued for their independence and their autonomy, we have someone who's relational. And instead of someone who is valued for their ability to reason and be a rational actor, we have someone who's valued because of their vulnerability, largely because of their embodiment that subjects them to possible pain at mental and physical levels, and their relationality that subjects them to kind of the deprivation of relations, social relations, kinship networks. So beingness is meant to value the alterity of animals by just honoring that fact that they're embodied, that they're relational, and recognizing that those two kind of realities make animals, just like all of us as humans, vulnerable, or can make us intensely vulnerable in certain situations. And that then the law has, a duty to respond to this. All right. So before, let me just go say one more thing about beingness. I theorize all of that again through drawing on critical theory from scholars who are addressing these issues and advocating for concepts like relationality, for vulnerability, for embodiment, not really perhaps thinking about animals, but then also really foregrounding the work of feminist care theorists like Carol Adams and others, ecofeminist theory, to suggest why these concepts also should be seen as applying to animals. And that's how I make the case for seeing animals as embodied, relational, and vulnerable. And that's what beingness can connote. And then in chapter 5, this is where I really take on the critique that so many animal advocates, kind of hear is, what about plants, right? And I don't want to be facetious about this at all. I really try in chapter 5 to engage with the work of plant studies scholars and even scholars discussing other types of non-human entities like robots, and thinking about, what are our ethical responsibilities toward kind of the robotic revolution that's with us now and, just coming on full force, to consider, am I just kind of redrawing a line a bit further down so that all animals are kind of included as legal subjects in the law and thus, given ethical and moral regard, and then foreclosing that possibility for other non-humans, and is that defensible? So in chapter 5, I take on the issue of plants, and basically I say, of course, the common law, which completely instrumentalizes plants as well, right, needs to have a much more respectful relationship and kind of characterization of what plants are, or even who they are, and that has to be completely transformed. But I also argue that beingness, or the legal being status, is not the subjectivity that should apply to plants, even if they also should not be seen as property. Basically for this reason, just as I stated earlier, beingness is meant to be a status that's as protective for animals as personhood is supposed to be. So, i.e., meaning that you cannot, kill a legal being or use them or exploit them in, an industry for others' purposes. So, beingness is supposed to be kind of, that full stop that personhood is theorized as being and is hoped to be. Of course, we know that even for legal persons today, that doesn't work, and more kind of scaffolding or social supports are needed. But beingness is supposed to be as protective as personhood. That being the case, given the fact that human beings, animals eat plants and will have to eat plants, i.e., kill plants, I say beingness is not then going to be an appropriate legal subjectivity for plants because it's not that protective stop for plants, right, as it's meant to be for at least human relations with animals. So this chapter, I hope, has tried to be attentive to all the reasons we need to kind of transform from our anthropocentric thinking, not just in relation to humans, but also to other non-humans like plants, but then also argue for why it is defensible to draw a line about beingness vis-a-vis animals. And so it takes like a biocentric reading of different entities, but then suggests that, it is defensible to have beingness only for animals and not, let's say, for plants. And I don't know if I have been successful in that. I'm sure I'll hear from my readers about that, but it was an exciting chapter to do, also daunting, because it really, I experienced as, writing in an area where there wasn't a lot of theorization of this kind of redrawing the line question. And we can understand why that is, because so many of us are so concentrated on making the case for animals. But I really did want to engage with kind of the critique I was making of liberal humanism, and to suggest why beingness was, not a suitable category for plants that perhaps other non-humans, that humans would, and animals would have to instrumentalize. Okay, and then briefly here in the concluding chapter, I set out some first steps for change. This chapter just does the work of summarizing the argument of why beingness is a corrective to personhood, not just to property, but to personhood. And then it goes into first steps to implement beingness, and then to remind us, in the interim, as we wait for the day when we might be in a majority position to think about a non-property status for animals, bearing witness to them through the law. Okay, so implementing beingness, some first steps. Step one would be the codification of prohibitions against animal use, animal exploitation industries, and perhaps new legislative principles as to how to understand legal decision making going forward. Step two, designing models for animal-friendly decision making. And then step three would be kind of also thinking about how to listen to animals, to partner with them, to discern their needs. It's meant to be, a new system that doesn't see animals just as passive objects, but as participatory agents in the process as much as possible. So on step one, codification of prohibitions and new legislative principles, I basically suggested that first, of course, there has to be a prohibition on all human or corporate trade in animals. Two, legal decision makers have to reject human exceptionalism. And three, there needs to be a commitment to listen to and respond to the needs of vulnerable others. In step two, designing models for animal-friendly decision making. Here I just wanted to really, flag that this is not like some whole new space where we have to think, quite radically about bringing in animals into decision making. We have other ways of thinking about the interests of non-humans already. For example, environmental impact assessments. We also have other ways already of thinking of how to integrate the perspectives of humans who may not be able to articulate their interests to others. So supported decision-making models. So that these are available. They may not be suitable for animals, but at least there are models available that show us it's not, a fantasy to think that we can advert to the interests of non-humans in our decision making. And also then step three is a correlate, listening to animals, to partner with them, to discern their needs, that often ask question, how can we know what animals want? And then I don't think the answer is to say, well, we'll never know, and so let's not think about what they want. And of course, the contrast is not to say, of course, we know what animals want, because that itself would be a very imperial position to take toward animals. Like, how could we say that? So here I suggest we need to accept the paradox and uncertainty of this question, and drawing again on feminist work in animal studies, to try to practice interspecies mindfulness, and taking Laurie Gruen's concept, practice entangled empathy. And then I talk about an example, if today the intensive farming system stops, such that all the animals going into the assembly right now for slaughter as property come out as beings, what to do with these animals? How do we care for them? How do we think about them? And so I go through that example. And here I suggest, if we think of the land-based farmed animal survivors, we would have to shift these industries and all the humans involved and dependent on them to more humane labor. There could be a system of creating sanctuaries for these animals now, who are obviously not able to live perhaps independently as we might imagine so-called wild animals do. A public system administered, a private system. We would, have to have ongoing administrative review of this kind of multi-species impact assessments, and perhaps some of the costs for all this could come from the animal use industries. And then, of course, I fully realize that this may seem incredibly aspirational and utopian. I do think, though, that wide-scale social change is possible. I think we've seen examples, on other social issues. Of course, we've seen very recent examples how a world can pivot to a different way of being very quickly when the need is seen to be there. And so I do think in the interim that there is value in bearing witness. And as I do in the book, I would just like, to end with this quote from Katie Gillespie's powerful book, The Cow with Ear Tack 1389, where she talks about, a different experience for animals. This cow called Sadie, who of course was in the dairy system, and then was able to finally, in sanctuary, have a different experience for her life and for her relations with other calves and cows, and then be grieved at the end. Thank you, everyone, for your attention. And of course, thank you to the Social Science Humanities Research Council of Canada for supporting the book as well. I look forward to your comments and questions.